They could have sued through private litigation. And in fact, according to the AG, they could have won. But guess what? No one sued because they were never harmed. There was no fraud that needed to be disgorged. Concerning the wreckage of the residential mortgage highlights his need to cast the run-of-the-mill transactions at issue into what they manifestly were not: high-risk financial acrobatics imperiling the global economy. Dorks.
And at the eye of the storm is Donald Trump, ripping families apart, threatening women's most basic rights. I'm running for Attorney General because I will never be afraid to challenge this illegitimate president.
Yeah, there it is! Look at that facial spasm. Big Tish in New York obliterated, suffering a major loss on appeal. We've covered this case. We remember it was emanating out of Judge Angoron's courtroom. That Areola Angoron, who we talked a lot about, who had the bonus torso photo, was sending emails to his classmates. Hey, look at my abs. Strange fella. But Tish came out, and Tishy was the one who, of course, was trying to take out Trump. And you remember her. We've talked a lot about Letitia, and got a judgment after a ridiculous battle where Judge Angoron was with his law clerk, his judicial clerk, and they were sitting at the same level. She was like tapping him on the foot. Alina Abba saying they're playing footsie. They moved the cameras around in the courtroom. The whole case was rigged as hell because they brought Michael Cohen in to testify, a convicted perjurer, and they went after other people like Trump's CFO, Alan Weisselberg, and they were trying to get him to flip on Trump, and the whole thing was ridiculous. So it went up on appeal, and we saw during oral arguments that Tish's lawyers were getting obliterated, and now the decision has come. Here they write: Judge Angoron. The background of this case: Areola Angoron, aka the Nip, issued an order, and now here is the decision. The first one that we talked about is from Moulton. He says, this is what's happening. Trump is appealing these decisions from Angoron, and he says there's a couple judges here who are of the 5 who have decided that Trump is liable. Okay, so they say there's a big split. We got like 5 different judges, 3 different opinions. It's, overlapping. They all agree, no, fine, it's done. But this guy says that they say, these 2 judges, Justice Renwick and I, we find that the Supreme Court, Areola, correctly found Trump liable in this rigged case with Michael Cohen, saying we agree with the judge that the Attorney General acted within her lawful power, like she's Big Tish, she can do this. And we also find that the judge didn't violate any statute of limitations arguments either. And there was a big argument on this, that all of this was basically precluded, and they were just taking, the most recent one and bundling that in, and then going back and actually discussing other cases where the statute of limitations had expired, but the judge was just saying, well, I'm not going to make that a part of my judgment, but I will allow it admissible as evidence because it shows a pattern in a series of conduct that is detrimental to Trump, is what the judge said. So he just kind of carved it out. So they said, that's all fine. Now, this decision is one of 3 issued by the court today. We got these 2 other decisions. Justice Renwick and I agree with some of the other judges on some point. We agree with Justice Higgett, who's joined by Rosado, that the Attorney General could bring this action, right? Nobody's saying she can't. Like, she has the power to bring actions. She can't bring corrupt hack actions that exceed her power. But if she's got a legitimate case, nobody's making the argument that she can't do that. However, our remaining disagreements with our colleagues are profound. In some, Justice Friedman finds the Supreme Court's rulings are infirm in almost every respect and would hold that the AG had no power at all. Now, he would dismiss the complaint outright. And Justice Higgett, while agreeing that the AG does have the power to bring this suit, finds that errors made require a new trial. And so this judge says, well, we cannot harmonize with our colleagues, and saying the record justifies what happened. The inevitable elapse of time and the difficulties mean we don't have to dig into this too much further, but none of the 3 decisions garners a majority. Higgett and Rosado join the decretal of this decision for the sole purpose of ensuring finality so that they can appeal, and Tish is going to appeal. And like Justice Friedman, we commend them for doing so. But unlike Friedman, we do not find that this necessary measure is unfair to Trump. This court previously imposed a stay on the judgment and more. Executive law empowers the Attorney General to bring a lawsuit seeking injunctive relief, restitution, and damages. And the provision that gives her the power to do this is to protect consumers from deceptive and misleading practices. Like, there's a she can't just sue people. There's a reason. Why? Protect consumers. Now, that provision is intended to protect not only the average customer, but also the ignorant customers, the unthinking customers, and people who don't know any better. Now, in determining whether Tish Tishy and her proof has met the standard of a capacity or tendency to deceive, which is going to be the requirement, certain elements of the claim may be relaxed. And he gives us some analysis. But this action is turning this law on its head. The leniency with which the courts have construed their requirements for pleading and proving fraud, which is a leniency that has been extended for the purpose of facilitating the use of this provision, is being used here by Attorney General James to apply this section to a scenario that has never before been applied or even thought to apply, just like they do regularly. Remember when they charged Trump, actually in the business fraud case, they had to go through the New York statute and like, well, it's going to be subsection E. Subsection E says other offenses could be under this provision, election law. And so we're going to put the spreadsheet crime and reconvert that into 34 felonies like that. Or when they did the 1512C stuff with the J6ers, remember that? They're like, this is like obstruction of documents. What? You just made it up. And they did it here too. And this judge is calling Big Tish out. He says the AG in this case has utilized the flexibility that's afforded to her to unwind complex financial transactions that were negotiated face to face at arm's length between privately held real estate organization, Trump and the current president, and ultra sophisticated banks, insurance companies, government entities who were advised by equally sophisticated lawyers, accountants, and other business professionals. Everybody was doing it by the book. Trump made his estimate of his valuation. They made their estimate. They did business like any other transaction. The AG, though, complains, writes this judge, and the Supreme Court found that the statements of financial condition, right, those documents saying the building is this big, it's got this much, assets inside, this is what it's worth, all the things. Trump provided the counterparties. They said that he overvalued certain assets. Well, he counted that space, and that's not livable space. That's a closet or something, right? However, each of these that he submitted included written disclaimers saying in no uncertain terms that the valuations were estimates, okay? They have not been audited. They're my opinion, bro. So you just read it and make your decision. You can say, this is ridiculous. Come on, Trump. It's not worth $200 trillion. He's like, all right, well, maybe not. But billion? Like, all right, so that's fine. So each counterparty was further warned that it should do its own due diligence in the documents and draw its own conclusions about Trump's net worth. And each counterparty actually did. They did it, as it was obligated to do because New York law says they have to do it. So everybody followed the law. Moreover, Trump paid all principal, all interest, all premiums that he owed. And no counterparty ever registered any complaint. No one complained. No banks ever said we got ripped off. Instead, Big Tish, the AG, began publicly accusing Trump of issuing fraudulent statements. But if any counterparty, any bank or any insurance company or financial agency had been dissatisfied with this transaction, it would have had the incentive and the resources to bring the claim. They could have sued through private litigation. And in fact, according to the AG, they could have won. But guess what? No one sued because they were never harmed. There was no fraud that needed to be disgorged. So on this appeal, writes this judge, Friedman, this is an appeal for nearly $500 million judgment. I mean, we know we just spend billions of dollars like it ain't nothing, like trans operas in the sub-Sahara. But that's a lot of money. Think about your business or how much it took you to generate your first $1 million in revenue and how much work that is. $500 million. They took 500 of those away from the president. Illegally, unlawfully, by partisan hacks. Say two of my colleagues have cited scores of cases in an attempt to shoehorn this case into this other law, and they have gone so far as to claim that the AG, by bringing this action, has possibly saved the world. From a replay of the financial meltdown in 2008. It's so great. How this might be is not explained, though. They don't really know. Now, despite their efforts, they're unable to point to a single precedent, not even one, for the use of this law to target the types of transactions that are at issue here, which are very clear, reasonable transactions. Bilateral, negotiated, arm's length transactions between highly sophisticated parties, no effects on any public markets, and the parties were completely happy. These were total successes across the board. And so given the absence of any public interest in unwinding these deals, since everybody happy, the buildings got made, New York got built, skyline's improving, I'm not going to pervert this law and stretch the scope of this provision to try to shove this claim in there like these other judges did. And moreover, even if bringing this action were within the scope of Tishy's power, the Supreme Court erred in granting her summary judgment as to liability on the first cause and then rendering a decision after on all of the other causes, saying, here's what happened. Big Tish simply failed to prove her case. release because she's so pathetic. And she didn't even really do much. She sat behind the bar on that first row in the pews and took her shoes off. And Alina Abba was saying, put your shoes, you're stinking up the whole building, Tish. Accordingly, this judge would reverse the judgment and dismiss the complaint entirely. And so thus, while I concur with the vacatur of constitutionally unsound and otherwise defective $500 million disgorgement, I dissent insofar as the main decree affirms the judgment as to liability and as to the award of non-monetary relief to the AG. And he continues saying, I note that of the 4 justices voting for main decision, 2 of them, Justice Higgett and Rosado, do not actually agree with the resolution of the appeal for which they're voting. All right, so this judge is like, well, even the majority that says that Trump is liable, these 2 judges don't agree. Higgett wrote in his that he and Justice Rosado believe that the grant of summary judgment to Tish should be reversed. They said that. So actually, maybe the majority is that she doesn't have the power, but these guys just voted this way for whatever reason. The judgment should be vacated and this case should be remanded for a new trial on all causes. So this judge, Friedman, says, I commend the other 2 judges for their selflessness in putting aside their personal views to allow this court to dispose of this appeal. Okay, so like, in other words, they're saying, and we just read it, that some of these judges will jump on the majority just to get some finality on it, okay? Just so that Tish can appeal it, we can close this thing out. But they're just doing that just for that reason. Like, they don't actually believe in the underpinnings of the holding. However, I find it remarkable that, although a 3-justice majority of this 5-justice panel believe that the judgment in favor of Tish should not stand because she has not carried her burden of proof of proving a violation of the law, the result of the appeal is an affirmance of the judgment, albeit as modified to eliminate the disgorgement. So it's like a compromise. So to draw a sports analogy, he says, this is really weird what's happening here. It's as if a team is awarded a touchdown without crossing the goal line. Yeah. In any event, it seems to me that the result I would reach is more consistent with the other judges. Higgett and Rosado actually don't think that Tish won. They're just voting with the majority to close this out. And I don't know why they're voting this way. He says so. All right. So this leads me to explain why, I guess, given that I am alone on this panel in my view that the complaint should be dismissed. And I am not voting for the result favored by Higgett and Rosado, namely the vacatur of the judgment and a remand for new trial, saying we don't need a new trial. Okay. This whole complaint needs to go. First, I do not believe that we can ignore the fact that ordering a new trial in a case in which the primary defendant and a witness is the president for 3.5 years would disrupt the political life of America. So a new trial, so we can go through this whole thing again with another nipple judge from New York. Shout out to Viva. Second, while it is obvious from the divergence of opinions among the justices of this panel that this case calls out for further appellate review, and an order by this court directing a retrial is not immediately appealable. And it seems inconceivable to me, says this judge, that defendants would stipulate to a judgment that carries a $500 million reward against them. And even if these other judge, this Higgett is correct, the other concurring opinion, that neither side should have been granted summary judgment, I agree with the main judge, Moulton, that the record before us, which is 100 volumes comprising nearly 50,000 pages, is more than sufficient to decide this case. We don't need a trial, another one. And so the question is, did Tish prove her case? And she didn't. Writing, during the time period relevant to this action, Trump ran the Trump Organization. And then he ran for office and won. But in successfully campaigning for her current office, this is a judge in New York writing, Big Tish in 2018, she repeatedly vowed to pursue President Trump and his associates, including members of his family, through any available avenues of legal process. And the crazy New Yorkers were like, yeah, Tishy Poo, we love you. In March, only 2 months after she took office, Big Tish opened an investigation into Trump's businesses. And she was running this whole time with her facial spasms, remember, illegitimate president, like just jumping out of her skin. On appeal to this court, from a proceeding to enforce a subpoena, we also had Michael Cohen come in and testify. So then, on September 21st, 2022, we got civil enforcement action under this law. Trump, 24 other people or so, according to AG, on more than 24 occasions, or 2 decades ago, in the decade or two, ending in 21, Trump issued the fraudulent SFCs. Okay, we got it. The gravamen of the complaint is that Trump improperly qualified for favorable terms, didn't properly disclose things. We remember the background. Now, on appeal, Trump makes 2 arguments in support of his view, apart from any issue about statute of limitations or the propriety of the relief. First, Trump argues that Tish lacks standing because this vindicates no public purpose at all. This is just political harassment by the New York AG, saying that Trump's conduct had no impact on public interest at all. It was a private transaction with a bank. And any injury that may have been caused was sustained solely by the defendant's counterparties, which were fully capable capable of seeking redress for any harm done to them. Now, Trump and his documents neither had the capacity or the tendency to deceive. Nothing he did created an atmosphere conducive to fraud, and so it should be dismissed. Now, the first argument is standing. Tish doesn't have standing, saying an argument they also made on another unsuccessful appeal of denial of their motion to dismiss. But Moulton and Higgett reject that argument. Moulton, but apparently not Higgett, would reject the argument out of hand. He says, well, there's a doctrine of law of the case, and our earlier decisions say that she can stand and has standing. Now, as to Justice Moulton and his suggestion that the counterparty, in this case the banks, he says, well, they may not be able to sue. Well, what happens if they, want to do business with Trump and they can't sue him because they want his business like a disaffected party? His suggestion, he says, well, it might be too costly for the counterparty to pursue a claim, has no relevance in this case. The counterparties are extremely wealthy financial institutions, and it's the Attorney General's theory that they were defrauded of hundreds of millions of dollars, is what she said. If these banks and their insurance companies did not think it worth their while to go recover hundreds of millions of dollars, well, then it's not clear what public interest the Attorney General is vindicating. Like, if they don't care and they have an interest in it, why do you care? It is no answer to say, like the main judge does, that the purpose of this is to protect the public at large, right? Stupid platitude. Well, this is of course true. The question here is, what is the public at large? Do they have any transaction interest in this at all? No. Most incongruous of all is the main judge's attempt to justify Tish's intervention in these private transactions. What is she doing here? On the ground, they wrote, the main judge, this could, quote, cascade into a disaster, which we constantly hear, right? Unless we do everything, we're all going to die. You're going to kill COVID, or illegals are going to fall out of airplanes or whatever. Says, on the order of the system-wide liquidity crisis, Trump's going to wreck the entire financial economy by getting loans with gigantic banks. Says here, Justice Moulton's resort to high-minded but overblown rhetoric, let's go, concerning the wreckage of the residential mortgage highlights his need to cast the run-of-the-mill transactions at issue into what they manifestly were not: high-risk financial acrobatics imperiling the global economy. Dorks. Basically what he wanted to write. For the purpose of shoehorning in these transactions into the law. The theory of causation, saying that Trump could cause a 2008 economic meltdown, and so because he could, then that might be something that fits under this law, because it could be the public at large, because this could, what if Trump does it? Then everybody's going to do it, and then all the banks are going to be broke. Saying we're just going to make it fit in there and try to turn it into something that it isn't. Now, interesting footnote. He says the main judge asserts that the congressional testimony of Michael Cohen, the convicted perjurer and liar, that supposedly triggered the investigation of Trump, somehow took the transactions at issue out of the realm of run-of-the-mill, whatever that means. However, Cohen's vague and unsubstantiated contentions about the documents that were used are the same type of allegations filed every year in hundreds of thousands of cases, just like this. If anything about this case is not run-of-the-mill, you know what it is? It's Tish repeatedly making politically motivated promises to use her office to pursue one man and his businesses and family. She started making those promises long before Cohen gave a supposedly pivotal testimony, and also far from run-of-the-mill is the hyper fast tracking of the processing of this action until we got the appeal. The appeal took forever, which is unheard of in cases of this complexity. To take one example, the Supreme Court, Angoron, the areola, he set a trial date 5 days after it decided the party's motion for summary judgment, remember, and they wanted to get it all done before the election, because Letitia James is a co-conspirator in a nationwide, global, probably Democratic operation to use multiple legal avenues to take out the president. 4 criminal charges, multiple civil infractions from psycho ladies who paint their trees blue and talk about their vagina cats. And people like Tish, not to mention Griswold and the rest of them, tried to throw Trump off the ballot repeatedly, had to go to the Supreme Court to calm them down. However, as previously noted, none of the transactions here resulted in any publicly traded securities, had any impact on securities. The Trump organization doesn't even do that. And loans were part of broad categories, and everybody knew what the risks were. Now, there is a debate as to whether one of the chief causes of the failure in 2008, assuming that such a failure occurred, was a lack of government regulation. Yeah, that's right. Although Moulton's opinion appears to take that side in that debate, I don't see how that is a reason to come into this decision at all. Tish's prosecution of this action is not part of any coherent prophylactic government regulatory program, however wisely or poorly conceived. It was an unprecedented ad hoc intervention into a successful, discrete, private transaction that only impacted the 2 people involved. resolved. Now, Higgett, the other judge, he rejects my view that transactions between sophisticated parties, he says, well, we should count those, whether they should be excluded. And he offers his commentary in support of that. He says, well, Deutsche Bank, in dealing with high net worth people, should be treated by the AG that anybody would, any consumers would be about their dishwashers or deceptive credit cards or anything else. Notwithstanding the rhetorical flourish, man, shout out to this judge, Justice Higgett is unable to suggest how any of the transactions at issue actually impaired the public interest at all, nor does he offer any concrete reason why, in the absence of that public interest, the monitoring and defense of the private interest should not be left to the people who, run the banks. In adopting Tish's reading of the statute, my colleagues are empowering her office to attack at will virtually any business transaction, regardless of its success or failure, and in the absence of any discernible effect on the public. This is because, as a moment's reflection will disclose if you just stop and think about it, a substantial business deal that goes awry, which even though none of the transactions here did, they typically will give rise to a claim by the losing party, saying, well, that was a fraudulent transaction. This is not surprising because it's pretty easy for inaccuracies to creep into these things. But Tish now has the power, according to them, to involve her office in any of these disputes, even if there is no fraud. If you say that this section of the law gives Tish the power to pour over private transactions, even successful deals, years after they closed, because she wants to go find at least two inaccurate or disputable statements in a discretionary, subjective, disclaimed statement of financial conditions and make something up, it's ridiculous. She can't, not even identifying any greater public interest at stake. In fact, the harm to public interest is what Tish is doing. And regrettably, the record makes plain that in this matter, we see an attempt to use this for political ends, this law. The proof of this is found not in anything written by me, but in the words of Tish herself. Specifically, as previously noted, Tishy, in her 2018 election campaign for her current office, repeatedly promised the New Yorkers who love communism and Tish that Trump would be the top priority. She said, I would bring him down. She made these statements long before 2019, when she thought that she was going to trigger all of this, said it long before Michael Cohen lied, a convicted perjurer, and a disbarred attorney, get him, in which he claimed that his former client conflated valuations. Michael Cohen, the convicted perjurer, they brought him in there, and Angoron's like, he's so dreamy. By far, the bulk of Cohen's testimony before the House concerned matters having no relevance to this action at all, and his testimony about the documents at the hearing was restricted to a handful of repetitive, conclusory, and unsubstantiated assertions that the documents contain inflated valuations. Here's what Cohen said. It was my experience that Mr. Trump inflated his total assets when it served his purposes, such as trying to be listed among the wealthiest people in Forbes, and deflated his assets to reduce his real estate taxes. He's like, okay, great. So you can take $500 million? Cohen, who, as he admitted during the hearing, is not a CPA, offered no analysis demonstrating the valuations were inflated of those documents. The SFCs, okay, so he's inflating the Forbes list, okay, and he's trying to reduce his taxes like everybody does. That doesn't mean fraud in another document, but the judge is like, well, it's close though. It's like a pattern there. Like, we need evidence, you maniacs. Furthermore, the next day in testimony before the House Permanent Select Committee on Intelligence, Cohen admitted that he did not recall President Trump ever, quote, asking him to inflate the numbers in the documents, because he didn't. Now, given the sketchiness of Cohen's congressional testimony about these documents and his dubious credibility as a man who had just pleaded guilty, among other offenses, to willful tax evasion, making a false statement to a bank on a credit application, it's inconceivable, says this judge, that Michael Cohen's testimony would have triggered an investigation by Tish, but for the political considerations involved, right? Inconceivable. There's no attorney general who would take a convicted perjurer, tax evader, false statement, congressional liar, and use him as the crux of your investigation, unless you just needed an excuse. Those political considerations are amply attested by Tish's earlier campaign promises to use her office's power to go after Trump. And her promises to pursue Trump are matters of public record. You can see it. They're all cited in the record. For example, on September 28th, Now This Impact YouTube channel posted a video where she called Trump the illegitimate president.
We are angrier and more deeply divided than we've ever been at any point in our history since the Civil War. And at the eye of the storm is Donald Trump, ripping families apart, threatening women's most basic rights, and running for Attorney General because I will never be afraid to challenge this illegitimate president.
Yeah, there it is! Look at at that facial spasm right there. So you can see, right? Facial spasms with this illegitimate president. She just can't take it, man. Just emanating out of her face. And so she said it. We know what she said. And she did this repeatedly. They're huge fans of talking this way. Says he's illegitimate, remember? And then they'll come out, lecture us like, well, Trump denied the election. She was OG. I believe the president should be indicted for criminal offenses, blah, blah, blah. So we know her story, but this judge does a great job chronicling it all, has it documented, says the AG also made similar statements while campaigning in 2018. All of that happened before Michael Cohen ever spoke at all. On June 27th, after the announcement of her candidacy, she posted on X that she looked forward to working with Democrats to take on Donald Trump. Now, although the webpage has been removed, her website apparently promised a review of Trump real estate and wondering why he suddenly started paying cash. Here, she called him an illegitimate president again, saying, I look forward to going into the AG's office every day. And the judge cites story after story. Tish, I've got my eyes on Trump Tower, blah, blah, blah. And, I want to point something out here on this, and I know this is not really, going to make a lot of people happy, but this will be used if there are indictments against, Brennan, Comey, Clapper, Obama, Clinton, any of them, Strzok, McCabe, pick them. They're going to do a very similar strategy, right? This is why it's not generally good advice for politicians to sort of talk about their offices. Now, the distinction here is that I think Trump can talk about his cases and these people because he was the victim of their crime, right? So I think that's an important distinction to point out, but the judges will do this, right? And you can see this. This is just a laundry list is really all this is. The judge, bop, 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 Tish, you're a hack, you're a hack, you're a hack, you're a hack. It's clearly evident. And I'm not saying judges will find that Trump's statements about, Comey, Strzok, Page, whatever, will fall into that category, but their defense attorneys absolutely will. They'll say vindictive prosecution, malicious prosecution. In fact, I think the LaMonica McIver, the body slam congresswoman, she is making those arguments now. Now, between winning the election in November 2018 and the Cohen testimony, Tish continued to make statements in a similar vein. In NBC News in 2018, she says, I'm going after anybody in his orbit, face spasming out all over the place. So he chronicles it, and now he says the main judge asserts that the political choice for the AG would have been not to bring this case. Yeah, right. She ran for office. It was her campaign promise. Judge, in the view of her campaign promises, Judge Moulton's statement could not be more at variance with the facts. She campaigned on it, Judge. And now he's saying, well, it can't be political because, why would she want to go after a private person? No, it was 2000. Yeah, okay. So yeah, our timelines are good. So the implicit characterization of the AG's commencement of this action as an apolitical course also ignores the polarized political environment that prevails today. And while no one would deny that Trump is a powerful adversary, he was a private citizen. He was an individual capacity at the time. He was not the president. And to be clear, I do not contend that Tish's promises or the infirmity of Cohen's testimony would preclude her from bringing proceedings against Trump if there was an actual public interest, right? If she has the law and the facts to do it. However, after having conducted an investigation of 3 years, all that Tish came up with was a claim that Trump inflated property valuations in bilateral arm's length dealings with ultra sophisticated banks without any of them seeking any redress for their complaints. None of the sophisticated counterparties even raised complaints. They said Trump paid every dollar he owed on time. Nothing in the misconduct is even alleged misconduct has the slightest bearing on the public interest, right? No public misconduct. No attorney general had ever brought suit before based on such a set of facts until Tish. Well, she is historic, that's for sure. And so in sum, says this judge, the words of the attorney general herself establish beyond a reasonable doubt that contrary to the view of my other colleagues and judges, this action was commenced not to vindicate the public interest in securing an honest marketplace or in Justice Moulton's terms to maintain market hygiene. This was brought out of partisan political motives. Now, whatever one may think of Trump's character and policies, the law was not enacted for the attorney general to go beat her opponents of her political party, but the way this is being used here, arbitrarily, selectively, and politically, and the way it's going to be used in the future as a result of my colleagues and their approval of an entry of judgment for Tish is the problem. Now, as expressed by someone else in amicus, our approval of this will allow political partisans to arbitrarily pick and choose whom to punish and whom to favor. So the precedent for this is being created by the court, and it's going to probably intensify. My colleagues' elimination of any requirement that a judgment be supported by public interest proof will inevitably make the use of the statute so selective and arbitrary, we're going to even have serious doubts about its constitutionality, whether they can even do this. Now, although not directly on point, the Supreme Court was on another case, now asking about fraud. And so the decision continues continues to go on. President Trump was very happy about this. He posted, he said, "Total victory in the fake New York State Attorney General Letitia James case. I greatly respect the fact that the court had the courage to throw out this unlawful and disgraceful decision that was hurting businesses all throughout New York State. Others were afraid to do business there. The amount, including interest and penalties, was over $550 million. It was a political witch hunt in a business sense, the likes of which no one has ever seen before. This was a case of election interference by the city and the state trying to show illegally that I did things that were wrong, when in fact everything I did was absolutely correct and even perfect. Every single dollar was thrown out. Even the penalties imposed by us by the corrupt judge, Angoron, one of the most overturned in history, Arthur Angoron. Man, he's going to have to put that in his newsletter. I wasn't given a jury, and during the course of the trial, which lasted a long time, was not giving one ruling in my favor by this political hack. But worse than him, if that's possible, was Letitia James, a corrupt and incompetent attorney general who only brought this case in order to hurt me politically. She is a Trump deranged lunatic. They made me bond the outrageous sum, which has never happened before, which cost me millions of dollars a month. It should have never been allowed to happen, and everyone knew it. Importantly, the vote was 5-0, all of it's disgorged, although as we know, there's nuance to it. It should have never happened. I'm so honored by Justice David Friedman's great words of wisdom, which should be read by everyone. We just read it, Mr. President. I would also like to thank the court for having the courage to make this decision, which is already going down as one of the worst business persecutions in the history of our country. Sadly, there are other cases against me that are equally disgraceful, including those headed by corrupt judges like Juan the Con Mercan in the business fraud case, 34 felonies. Also, with Michael Cohen, says disgraceful, whose daughter collected millions of dollars in fees from crooked Joe Biden and Kamala Harris, while her daddy judge father shockingly refused to recuse himself from a vicious and corrupt trial, which is also under appeal, one in which every legal pundit in New York said there was no case. Even editorial board said, do not do this. But Judge Mercan gave me an unprecedented gag order, because he was also part of the Democrat onslaught to try to stop Trump before 2024. Many lawyers and appellate judges, including the gag order, not letting me talk about him or his Democrat daughter, or the fact that the appellate judges thought he should not be doing the case, but he did it anyways. Many lawyers said that his daughter and him created the greatest conflict of interest they had ever seen. Judge Lewis Kaplan, the other remaining case, which is the E. Jean Carroll case, the vagina painter, says the other remaining case whose wife, family, and friends attended his two trials is as mean and nasty as anyone I've ever met. Judge Lewis Kaplan brought his wife, family, and friends to the trials like it's a show? What a loony. Is as mean as nasty as anyone I have ever met. That case, also on appeal, should also have never been brought, and that was really concocted by George Conway and Molly Jongfast, whatever she does. Is as mean as nasty as anyone I've ever met. That case is on appeal, and he should be admonished for abuse and every other thing that can be thrown at a corrupt judge. He loved the publicity and would not let us present irrefutable evidence that we wanted to present. The Clinton-appointed judge should not be allowed to get away with this scam. These were all political trials in an effort to destroy my viability as presidential candidate before, during, and after the election. They were strongly coordinated with the Biden-Harris campaign and will go down in history as the most corrupt cases ever brought. These two cases are even more ridiculous than the corrupt Letitia James case and will be found out to be so in the very near future. All these judges should be ashamed of themselves for allowing them to happen. They are political hacks who did everything possible to hurt me as a candidate. This was an attack by the Biden-Harris administration on their political opponent, me! It is such an honor to have withstood it, thrived, and even become the president of the United States despite the horrible things that were done to me. I'd like to thank and congratulate my son, Eric Trump, and all of the many people in the Trump organization that fought so strongly for justice. My legal team refused to give up against heavy odds. This is a great day for New York City and state. From President Trump. A well-deserved celebration. My goodness, he deserves every word of that. So does the Trump org and the rest of the family who's there, who's gone through this, because this was just one prong of a multi-prong and multifaceted attack, and it was a big one. $500 million that's been just like taken from you because Tishy decided to to run for office and her communist Democrats in New York support this type of law. Now, victory, vindicated. Trump's not paying them a dime. And Tish says, here's what we're going to do. We're going to appeal this. She said she's not posting comments like this anymore. Remember those? Hey, Tish, where's your new countdown? You want to repost $0.00 there, Tish? Because you're not getting it. So here's what she posted. The First Department today affirmed the well-supported finding of the trial court. Not really, like kind of. Those two judges who voted for it were just doing it to bring finality to the case. His company and his two children are liable for fraud, whatever. This court upheld the injunctive relief we won, limiting Trump and the ability of his officers to do business in New York, whatever the details of that are. And so whatever what she says the limitations are, like they have to check in with somebody or something, it should not be lost to history. And I think they do. I think they actually have to file reports to Angoron. So it's like minor just oversight. Actually, remember they appointed a special master or whatever to keep track of things, who's getting paid by Trump, right? In front of one of the judge's friends. It should not be lost to history that the president violated the law and that our case has merit. Doesn't really. We will seek appeal to the Court of Appeals and continue to protect the rights and interests of New Yorkers. Womp. So Tish will fight and probably get obliterated again because she's legally incorrect.